Section 34 of the Labor Act 11 of 2007. This section deals with dismissal arising from collective termination or redundancy. In terms of this section, if the reason for an intended dismissal is the reduction of the workforce arising from the reorganization or transfer of the business, or the discontinuance or reduction of the business for economic or technological reasons, an employer must, at least 4 weeks before the intended dismissals are to take place, inform the Labor Commissioner and any trade union which the employer has recognized as the exclusive bargaining agent in respect of the employees of the intended dismissal, the reason for the reduction in the workforce, the number and categories of employees affected, and the date of dismissals. If there is no trade union recognized as the exclusive bargaining agent in respect of the employees, give the information contemplated in paragraph A. Now the for information to the workplace representative elected in terms of section 67 and the employees at least 4 weeks before the intended dismissal. So if they are not members of a trade union, then such information must also be given to the employee representative that's appointed in terms of section 67 of this Labor Act. Now, subject to subsection 3, disclose all relevant information necessary for the trade union or workplace representatives to engage effectively in the negotiation over the intended dismissals. Negotiate in good faith with the trade union or workplace union representatives on alternative to dismissals, if there is any other alternative, the criteria for selecting the employees for dismissal, why are those the specific employees chosen, how to minimize the dismissal, the conditions on which the dismissals are to take place, and how to avert the adverse effect of the dismissal, and select the employees according to selections criteria that are either agreed or fair and objective. Despite subsection 1A and B, an employer may inform the trade union or workplace representative of the intended dismissal in less than 4 weeks if it is not practicable to do so within the period of 4 weeks. So although the 4 weeks is what is required, if it's not practically possible, then the employer may inform the trade union or workplace representative of the intended dismissal in less than 4 weeks. When disclosing information in terms of subsection 1C, an employer is not required to disclose information if it is legally privileged, or any law or court orders or prohibit the employer from disclosing it, or it's confidential and if disclosed might cause substantial harm to the employer. If after negotiations and selections contemplated in subsection 1, the parties do not reach an agreement, either party may within 1 week after the period referred to in subsection 1 or subsection 2, refer the matter to the Labor Commissioner, who must appoint a conciliator to assist the parties to resolve their dispute. After appointment in terms of subsection 4, the conciliator must, as soon as it is reasonably possible in an attempt to resolve the dispute, convene a meeting of the parties and may convene additional meetings as may be necessary up to maximum period of 4 weeks as from the date that the dispute was referred to the Labor Commissioner in terms of subsection 4. During the period referred to in subsection 1, 4, and 5, subsection 1C and D continues to apply to the employer with necessary changes. So subsection 1C and D continues to apply. Now our subsection C is disclosure of relevant information And the subsection D is basically negotiating in good faith and looking at alternative ways to dismissal and other criteria, and also considering the criteria that are used in selections and many other requirements that are referred to under section 1D. Now, during the period referred to again, the employer may not dismiss employees in terms of this section unless the dispute has been settled or otherwise disposed of. So remember, you have only given a notice that you would like to do so. So only after a dispute has been settled, if an employee or employees are unhappy about the said dismissal, then that dismissal remains on hold until the matter is disposed of by the Labor Commissioner. If there is a disguised transfer or continuance of an employer's operation, which employs or employed employees who are to be dismissed or were dismissed in terms of this section, the employees or their collective bargaining agent have the right to apply to the labor court for appropriate relief, including an order directing the restoration of the operation, directing the reinstatement of the employees, or awarding loss and future earning. Nothing contained in this section prevents an employee from referring a dispute of unfair dismissal or failure to bargain in good faith to the Labor Commissioner in respect of the employee's dismissal. So the employees can also raise an issue on unfair dismissal in cases where they feel that this is just done to actually unfairly dismiss them, and nothing stops them from still lodging a case of unfair dismissal with the Labor Commissioner. For the purposes of subsection 7, disguised transfer or continuance of an employer operation includes any practice or situation whereby an employer who runs or operates any business purports to have gone out of business or to have discontinued all or part of or form of the carried out at another location without the employer disclosing the full facts to the affected employee or their collective bargaining agent. An employer who contravenes or fails to comply with this section commits an offense and is liable to a fine not exceeding 10,000 or to imprisonment for a period not exceeding 2 years, or to both the fine and imprisonment. Now that brings us to the end of section 34. Let us discuss, let us engage in the comments or any of our social media platforms. Thank you.